Welcome all. Today I am going to discuss with module 10 person with disability. Myself Dr. B.S. Patil. I am associated with V.M. Salgaonkar College of Law, Goa. In today's discussion, I am going to take up a discussion on access to justice in the light of disabled persons. In this discourse, I am going to take up a discussion on the understanding of concept of disability, the theories which are going around explaining what is disability, the process of rehabilitating these disabled persons, and then finally, I will move on to few of important legislations which provide access to justice to these disabled persons. The expected outcome of these proceedings would be to understand the disability from the access to justice point of view. And during the discourse, I expect you all to understand the concept, theories of disability and the rehabilitation models that has been developed by the civilized world for these disabled persons. And also I expect you all to learn that the statutory provisions that has been created, established and implemented for the sake of protecting persons with disability. So, to begin with, the discussion would be on the disability and its relation to the civilization. How a disability can be related to a civilization? This reason is simple. A disabled person or a disability as a whole is a challenge to the society. We who claim to be a civilized world, we are under the duty to establish a society which can treat each and every person equally and with dignity. Now, this challenge to treat each and everybody with dignity, whether we have accepted the challenge, whether the challenge has been accomplished, this is what establishes the civilization level. So, therefore, disability is basically like a disease cause injustice to the person by limiting the range of opportunities which ordinarily a normal person enjoys. So, therefore, when a person with disability comes to an institution, the institution is under the duty to provide equal range of opportunities as of a normal human being. So, therefore, whether we have achieved the civilization which is supposed to be a dream to be achieved by the human being, I say that whether we have achieved is still a question mark, because to study our achievement, we need to study the conditions at the edge of the society, not in the middle of the society, because the edge of the society they reveal the conditions, the state and the progress of the society. And I consider disabled, this is a micro minority called persons with disability are staying at the edge of the society. The moment they enjoy the rights, the dream of civilization could be achieved. So, therefore, I suggest that the rights of disabled person should be treated as a touchstone to determine the extent of civilization the society has achieved. So, disability comes up with the prejudice. In the medical paradigm, disability is considered as a dysfunction. So, this advantage, or I should say the drawback of this prejudice is that it comes up with an understanding that the curable person, eradicate the incurable person. Now, here we are talking about extinguishing a life only because the society cannot provide him with equal rights. The disability of the society is being treated as a disability of a person. So, this prejudice can lead to a situation where they only provide medical help and then they consider the disabled person as a cursed person. So, this prejudice needs to be addressed. So, this is the first thing that we need to understand. So, the question is why I am discussing all these things under the heading of access to justice. So, here I want to mention that access to justice gets an entirely new meaning when we discuss persons with disability rights. Expecting a disabled person to go to court and access to justice, it is meaningless as long as he has been given equal rights along with others, right to live like a human being. So, therefore, when access to justice is discussed in the light of persons with disability, entitlement becomes access to justice. Whether the dignity, the life with dignity becomes access to justice. So, here in this discourse, I am not going to discuss the right of a disabled person to reach court, but I am going to discuss the right of a disabled person to live with dignity. So, disability, is it a grave concern, a matter of a grave concern? Yes, indeed, because disability is, even though we call it as a micro minority, it is not actually a micro minority. Almost 600 million population of this world are disabled persons. Why they are micro minority? They are not only micro minority, they are invisible minority, because of they confine themselves to the four walls of their house. They do not move around in the society. So, as we do not see them, we feel that they are not present, but they are very much present in this world, but only thing is we are not provided them with the proper rights and duties. Poverty and disability, they are correlated with each other. Disabled person ends up with a poverty because of lack of opportunity. That is the reason why this is a matter of a grave concern. Disabled persons education is also limited as the range gets restricted because of his disability. Disability again creates a impact on the economy of the state, as traditionally we feel that the disabled person cannot contribute to the economy of the state, which I want to mention here that it is not true. They cannot contribute to the economy of the state because they are not being empowered. If a person with disability are empowered, they are as good as any other human being. So, 2001 census also revealed that there is a large portion of people who suffer under disability. Now, disability, poverty, they are correlated. Now, this poverty and disability is a vicious cycle, and it is explained on this slide, where disabled person suffers from poverty and the poverty leads to ill health, malnutrition, and further this ill health, malnutrition leads to disability. The inner smaller cycle suggests that a disabled person is denied of his political and economic, social, human development because of limited range of opportunities. His social, economical, human development index would be at the lowest. Absence of these developmental index leads to a situation where he do not exercise his political and civil rights. As a result of that, social and economic rights are also avoided. So, finally, he would suffer from social exclusion. So, like this, disability is not one problem with physicality. Disability is a problem related, it is a multiple problem, and the approach should be of from all directions to solve this challenge. Now, taking the concept of disability into consideration, disability is recognized under three different terms: impairment, disability and handicap, whether they are one and the same. If they are different, how far they are different from one another. So, take impairment. The impairment is basically a term used to describe anatomical structure of a person. If a person is suffering from anatomical disorder or psychological disorder, that is considered as a human being is been impaired. This impairment becomes disability if this disfigurement, anatomical disfigurement, psychological disfigurement leads to a situation where his range of opportunities gets restricted and his activities gets restricted. So, restricted activity of an impaired person is disability. So, this disability leads to handicap when this restricted opportunities leads to a distinctive disadvantage to the person. So, take the example of a blind. A blind, blindness is an impairment. Due to blindness, he cannot pursue his education is a case of disability. Lack of education leads to a situation that he cannot obtain a degree, he cannot pursue higher studies is handicap. So, therefore, these are the three different terminologies used for three different purposes. Many a times we use these terms interchangeably. Taking theories of disability into consideration, the first theory I am going to discuss is a sociological theory. So, in this sociological theory, disability is considered as a person in need of help, but it is not as simple as that, because in a sociological theory there are various other people in need of help. So, when you look at the people in need of help, person with disability stands last in the line. So, stable and developed countries consider disability rights as the rights to be protected, but whereas underdeveloped countries take an excuse that there are many other things to do rather than supporting a person with disability. Same with the developing countries. So, therefore, in sociological theory, each society looks at the disability from a different paradigm, and this difference is maybe on economic status or maybe a religious basis or even maybe a cultural basis. Take the example of a blindness again. USA takes blindness as a situation which needs assistance or counseling, whereas England takes it as a technical challenge where they need to develop a technology to address the problem, whereas Italy looks at it as a situation which needs intervention of a god, which needs a counseling. So, this is how same disablement is looked differently from different states. Positivist theory. This positivist theory speaks about cures. So, if a person is suffering from any kind of disability, he should have clinical intervention, medical intervention and try to cure the disability. But this they also have developed social medicine for this, wherein the chances of disability can be prevented. So, that is the positivist theory, where they look into positive action into addressing the disabled person. But the major defect with this system is the life and the death decision of a person is decided by somebody else. No questions are asked, no opinions are sought. Disabled person has to undergo the treatment what the other person is suggesting. So, the positivist theory is a theory where somebody else decides on the lives of a disabled person. Then comes the functionalist theory. So, in this theory, the society consider disability as a sick role. Here, the disabled person, it is considered as a sick person who needs who wants to get well and he needs to be treated. This functionalist theory is okay when it comes to curable diseases or curable disablements, where there are n number of incurable disablements are there, for which this functionalist theory is not answering those requirements. Then the critical theory. Now, the critical theory is a theory where they consider disablement as or disability as result of an unequal society, and this unequal society has to be brought into an equality level through social action, through social revolution. Again, here we are talking about equality without considering the variety of problems which disabled people suffer. So, these are the different theories of disability. Moving on to the rehabilitation. So, the rehabilitation of a person with disability, here we are having a different modes of rehabilitation. First, let me take up medical model as a rehabilitation. According to medical model, disability is a medical challenge. The disability can occur due to disease, trauma or other health conditions. So, medically these conditions should be treated. So, therefore, treatment by the professionals is the way a disabled person can be rehabilitated. That is the opinion under medical model. But if you look at the understanding of this whole process, cure or the individual's adjustment or behavioral change, that would lead to an almost a cure situation. So, cure leads to one option is cure the disease, second option is lead to a situation of almost cure position. If you look at the next model is a social model. According to this model, disability is a socially created problem and a matter can be resolved with full integration of the individual with the society. So, therefore, how to achieve this is again through social action, collective responsibility and make environmental modifications, so that the disabled person can move freely around in the society. Now, here the issue concerning with this social model is both cultural as well as ideological. Many a times the cultural hindrances are created to this model. Charity model. Now, in this model they consider person with disability as the victim of circumstances and he deserves pity. At the same time, no rights for him. As he is a victim, he needs certain kind of a help, assistance. So, he would be given a certain kind of facilities, but never rights. So, in this model they expect person with disability to live an animal existence without any kind of rights. In moral model, that is the next one, where they consider disability as the result of bad actions of parents or bad actions of the same person in the earlier life. So, therefore, they consider disablement as a punishment given by the God. So, in Hinduism they consider it as a part of doctrine of karma. So, curing them, protecting them, giving them rights can never be thought of, as they have been punished by the God himself. Then comes the last human rights model. Now, in this model they consider person with disability as the person with different abilities. So, we need to protect his rights rather than provide him with the charity, and therefore, human rights model provides for empowerment of persons with disability rather than providing them with any kind of charity or facility. So, moving on from the theories, the models of rehabilitation, the concept of disablement, let us take up the discussion on the laws concerning disability. The Constitution provides for many provisions for persons with disability. Article 41 speaks about providing education to the person suffering from the disablement. 39A provides for equal access to justice and free legal aid. 45 provides for early childhood care and providing education till the age of 6. 46 and 47 provides for raising the standard of living of and education and the development of persons with disability. So, that is how the Constitution has ample provisions for protecting the rights of disability. So, from the Constitution, let us move on to the legislations for the protecting the rights of the disability. As a first discussion, I am going to take up the protection given to the persons with mental illness under the Mental Health Act. So, if you look at the evolution of Mental Health Act, it has started from 1858, where they had built many asylums for lunatics. Then there was Indian Lunacy Act in 1912. Then came the present legislation, the Mental Health Act 1987. This act provides for a specific object. The first, the restriction. The Mental Health Act is restricted only for a persons with mental illness. Then the object of the act, it provides for establishment of psychiatric hospitals and nursing homes for the treatment of persons with mental illness. Then in addition to establishment of the hospitals, it also provides protection to the properties of persons with mental illness. So, when we talk about mental illness, the person cannot take care of himself or his own property. So, there is a need for higher level of protection to the property belonging to the person with mental illness. So, how does this act provides protection? So, section 50 empowers the district court to intervene with the management of the property, management and also take care of the property. District court can be intimated or can be called to intervene not only by a person with mental illness, but can be by any relatives, next friend, curators, advocate generals. So, there are series of people who can intervene into the functioning or maintenance of the property belonging to the mentally ill person. So, once the district court is intimated about the property and there is no proper care of the property that is going on, then the notice is issued to all the stakeholders and the hearing is conducted. The hearing is conducted with two objectives, that is whether the person is suffering from mental illness, if yes, whether he can take care of himself or he cannot take care of himself. So, once these questions are answered in affirmative, then the court will go ahead and appoint a person to take care of the property. The appointment is of two different kinds of persons. The court appoints a caretaker. If a caretaker is appointed to take care of a person of the mentally ill person, then he is termed as guardian, but if he is appointed to take care of the property belonging to the mentally ill person, then he would be considered as manager. So, after appointing the manager or the guardian, the court enjoys the series of powers to take care of such property. So, after appointment, the court will be conducting the supervision of the functioning of the guardian as well as the manager. If court finds him not functioning properly, then he can be removed, maybe on the application of the parties or maybe suo motu on its own. If the mentally ill person is indigent, then at the cost of the state, the district court can admit him to any psychiatric hospital. If he has a property, then the court can ask the proceeds of the property, that is the income of the property, to be spent on the treatment of this mentally ill person. So, this is the brief discussion as to the entitlement of persons with mental illness. Moving on to the next discussion, that is the Persons with Disabilities Act. Now, this act was enacted to fulfill the international obligation on the India, that is India had signed proclamation on full participation and equality of the people with disabilities in the Asian and Pacific region. After signing this convention, they were in need to pass the legislation. As a result of that, we have come up with Persons with Disabilities Act. The act has an objective to ensure full participation and equality to the persons with disability, and to ensure that they have also established a series of authorities with a series of powers. The highest authority under the act is Central Coordination Committee. This committee is a national focal point, and this CCC would help in developing comprehensive policy and evolution of comprehensive policy for persons with disability. They work as a bridge between the department of the state and NGOs, and they keep advising the central government in coming up with new projects for persons with disability. They take up individual cause of persons with disability and fight a case in the court of law, or it can also make a recommendation to the department. Further, the Central Coordination Committee work with international organizations also, and the projects of the international organizations in India would be reviewed by the Central Coordination Committee, and also they take steps to ensure barrier free environment and monitor and evaluate impact of the policy on the society. So, like this they have been made to work on various aspects. Similar to this Central Coordination Committee, there is a State Coordination Committee, which has got similar functions, but with a geographical restrictions. So, therefore, what we have as an authority under PWD Act are the central government has Central Coordination Committee assisted by Central Executive Committee, whereas state government has State Coordination Committee assisted by State Executive Committee. So, what is this executive committees does? They again function to bring in the policies of the Central Coordination Committee into action. So, basically the Central Executive Committee is a foot soldier of Central Coordination Committee. So, similarly, there is a State Executive Committee which function under State Coordination Committee. So, moving on to the next entitlement process, that is the Rehabilitation Council of India. This act was passed in the year 1992, and this act was created with the object of establishing Rehabilitation Council. This Rehabilitation Council is a professional body. This body indulges itself into training the trainers who are going to in turn empower the persons with a disability. This Rehabilitation Council indulges in various different kinds of trainings which can improve the economic condition of a person with disability. So, the Rehabilitation Council consists of chairman with a social work background, members from various departments including UGC, General Indian Council, Director of General Indian Council, Medical Research Council. So, the variety of members are included, including medical practitioners and the parliamentarians. So, moving on from Rehabilitation Council of India to a bill which is still under the pipeline, that is Rights of Persons with Disabilities, Draft Bill 2012. So, this is yet to be enacted, and this is one bill which provides access to justice in its traditional sense. This bill ensures access to the court. Till now, when we discussed Mental Health Act, PWD Act, Rehabilitation Act, all these were mostly concerned with entitlements, but this is the act which considers access as one of the right. So, here the act, that is the bill, is passed with an object, or the bill is been drafted with the object of providing legal capacity to the person with disability, and to provide him with the legal facility, it also suggests making suitable arrangements. So, in the legal capacity, the disabled person enjoys right to move court. So, when he has a right to move court, the court has to create reasonable accommodation for this person with disability. So, reasonable accommodation in the sense he should be given the documents in the form in which he could read. If a blind person moves a court, then he should be given all the documents in a braille language. Then no discrimination against person with disability due to his disablement. National and state legal service authorities also should make provisions for making the documents available in different methods by which a person with disability can easily access. So, therefore, the bill creates an obligation on national and state legal service authorities to create documents in a different fashion. The important authority that is established under the bill is the Disability Rights Court. Now, this is a court established to take care of the disputes connected with the persons with disability. He may be a victim of an act or he may be an offender of an act. The case would be heard by the Disability Rights Court, and this court is expected to dispose of the cases speedily. Mostly the state government recognizes existing court as a disability court, but sometimes they are empowered to establish a new disability court if there is a more population of more than 10 lakh in a city. Disability court comes up with Disability Right Council. So, where the free legal aid is provided to the person with disability. Then comes the National Trust Act, which is passed in the year 1999, and this act is passed with the object of maintaining a national level a trust for persons suffering from autism, cerebral palsy, mental retardation and multiple disabilities. Under this National Trust Act, there is a provision for appointment of a guardian for the person with disability and a provision and an ability to lead an independent life. And this National Trust Act is expected to fulfill all the objectives of the PWD Act. So, in conclusion, I want to mention that the laws on access to justice in a traditional sense do not exist in India. So, there is no provision in which a person with disability can approach court, and there is no provision by which he can access the justice. A person with disability can access justice because he may be a poor, but not because he is a disabled person. So, traditional sense still there is a lot to be done, but in a modern view where entitlements also can be considered as access to justice, there are provisions which exist, but still there is a need for sensitization of the society and there is a need for implementation of the law effectively. Thank you.